Right. Okay, welcome everybody to Senate Economic Development, Housing and General Affairs. It's good to have a full room. Clearly lots of interest in this bill as it comes back to us from the House. This is one of this labor bill now has most of our labor work other than S-173 in it. And we are looking today at the additions put on by the House, the very, very narrow non-compete work that was added to this bill. And we have a proposal from the, in addition to hearing about the non-competes, we have a proposal from the VSEA. So I believe to begin the discussion about the non-competes, we are welcoming Austin Davis. Austin, introduce yourself and go for the guest. We're on S-230.
Good morning. Yeah, for the record, Austin Davis, Director of Government Affairs, Lake Champlain Chamber. Since this is the end of session and time is tight, I will take my best efforts to make these remarks very brief. And then I think Dave Harlow is in the room and speak to some of the more technical aspects of the law. I want to focus my remarks on 4 main points to bring to your attention and the effort to be brief. Just the business perspective on the use of non-competes, how we got to this exact point in this legislation, how the Fair Labor Standards Act is a bit of an apple to orange is test for this, which will lead me to a very narrow and I believe friendly amendment that we might have with this. But backing up real quick, I just think it's good to give some context, what a non-compete agreement is. It's a legal contract or clause where the employee agrees not to enter into competition with their employer for a specific period of time and a specific geographic area with a specific scope of work after their employment ends. In most states, including our own state, a non-compete agreement is enforceable if it meets a reasonable and standard. And the court generally looks at is the duration reasonable. In Vermont, it's generally about a year duration. Is the geography reasonable? And is the scope of work making sure that the person's not doing any work, but not doing the work that directly competes with their employer, where there might be some impropriety there. These need to be applied judiciously. And I think Vermont's current reasonable standard and its rich body of case law has shown that they are being used judiciously. I think it's important that most of the work around non-compete agreements is done in a judicial setting, because these agreements are really meant to cover many gray areas, and you need to look at them in the totality of the issue, in the employment relationship, and all the criteria and circumstances. We haven't seen any issues around the status quo of the reasonable standard. We don't see it being abused, and I think we've heard some egregious examples from outside of our borders, but we haven't specifically, in the 8 years we've been discussing this over in the House, haven't heard egregious examples within our borders. I think in my interactions with employers, I've seen them being used judiciously. Employers understand that these agreements can also have an effective scare for talent. So if they're using them, they've done the internal calculus to understand that what they need to protect is so valuable that it's worth oftentimes reducing the talent pool, which they can draw on to fill that position, because some folks will not come to a role that has a non-compete agreement. There's, like you said, a body case law that follows this. And then I think finally, one thing that's lost in this discussion is that there's an important ethical component to this. I think that's best embodied by the fact that you all are covered by an agreement, while not in name is a non-compete agreement. In effect, is a non-compete agreement. Legislators are banned from lobbying for 1 year within the state of Vermont,
Unless it's a state agency.
Unless you're going to a state agency, in which case there's a similar
That's a pretty
agreement.
big loophole, as we have discovered in this building.
Well, once you leave a state agency, there's a similar agreement as well that prohibits lobbying for 1 year within the state of Vermont. All the elements of a non-compete agreement are there, and that's an ethical consideration. And so we always would ask legislators, if they think that there's an ethical issue within a person leaving a position where they are entrusted with certain information and certain relationships, that they might then go abuse. If they think that's important enough to protect in the context of a legislator or an administration official, it's certainly important to protect in the context of an employer in our state. Many of our employers in our state are small shops, they're small businesses, they're competing at a national and international level, way above their weight class. And some of their first mover advantage or intellectual property could be very easily trampled if folks can just easily poach those employees rather than buying that property. You might say, well, there's intellectual property law, there's trade secret law, there's all these other things. They are all part of the ecosystem, but really it's about the interstitium, the gray area between all those things. And sometimes things might not actually be, intellectual property, but they are important. Sure, I can use intellectual property laws to go after an employee who leaves to go to my competition and brings the special sauce formula. But I can't do anything about the fact that they were there for the creation of the special sauce and they know the 700 ways to get to it that aren't unsuccessful. So if they want to move to the next thing, they have that. And that's not necessarily protected.
So this is a very narrow non-compete clause for non-exempt employees. This was supported in the House. I believe you ended up landing in support of the House, my understanding from the chair. What is it that you think needs to change or that you were not happy with in the House version?
If I may, I just want to get through one more point. I'll get to that. Just the historical context is helpful. So I was just getting some of the overlying background of non-competes, how they're used, how they're traditionally used. The part number two is none of this happened overnight. There's been a 8-year discussion in House Commerce Committee around this. This last summer, there was a working group with many people who care about this, that worked on this issue. It resulted in...
You were on that.
That's right.
Yeah.
It ultimately resulted in H205, which came out of House Commerce. Unfortunately, that legislation got waylaid because of a last-minute conversation around teachers and their agreements that are statutory agreements that were ruled by Legislative Council to be non-competes. That made 205 go back on the wall of commerce, and then that led us to a situation where the chair of House General took it upon themselves to create a short-term quick fix. And I think it's very impressive the work that House General did in such a short amount of time. Sometimes I think maybe it's because they didn't have the 8 years of history that they were able to do that. The outcome didn't make everyone happy, but I think we all landed in a place where we felt this was a reasonable outcome, certainly.
Thomas.
On that point, did the chamber have a strong opinion in support of H205? And simultaneously, do you have an opinion on the Hedrick amendment that ultimately tanked? Would you have objections to removing that non-compete for teachers?
I don't want to get involved in I think you should talk to the Principal Association, the Superintendent Association, the School Boards Association. I think they all have very strong opinions on.
But do you?
We don't. I think that we went through 8 years of discussion without the teachers ever being involved. And then we went through about 4 months of discussion without the teachers ever being involved. It was only when it came to the floor that discussion was had. H205 had some things that we weren't necessarily happy about. We could have seen a different version. At the end of the day, politics and legislating the art of the possible. And I think we ended up with what was possible with H205. It was an unfortunate reality that it got sent back to the wall because of that floor procedure.
But you were supportive of H205 otherwise.
Yes.
Thank you.
So I think, again,
So just to clarify that,
Mhm.
you were on the task force, and then were you involved in also helping draft? Did you have input in drafting 205 as it is on the wall?
That's right.
Right.
And so, to be clear, what you're seeing here is something that was created, in about mid-March by House General as a way to move something
Some piece
related to that. And none of the language actually in 230 right now was really discussed in House Commerce as part of H205. I'd say the solution actually was probably in the past brought up a few times in the many years that this has been discussion in the legislature. And each time I'd say it kind of got pushed aside for various reasons. But here we are.
Okay.
So that
I
brings me
need, I
to,
need your ask.
Yeah,
because
me
I've got,
too, yeah,
we've got
2:30.
another whole aspect of this bill we have to talk.
so 230, uses the Fair Labor Standards Act that exempts non-exempt, which was originally created in the 1930s to address overtime and scheduling of employees. Is never really intended to be related to competitive threats or possession of sensitive intellectual property. So I think, while this represents a workable solution, it's not obviously the best solution. I think you will hear that from everybody. Everyone might have other ideas, but this is one of the best things we've actually had in the long 8 years discussion around non-compete agreements.
That's 205 or this.
S230, what's before you right here that Chair Mahali put together. That said, there is a narrow concern that some individuals might be, and Dave Parlow can speak more to this, but there is a narrow concern that there are some employees who will be non-exempt, but will make high salaries and will be in situations where they are exposed to competitive materials and intellectual property. A good example of this might be an executive assistant, because they might have a higher salary, but because of the Fair Labor Standards Act duties test, they will not meet the criteria of an exempt employee, but they will be in with the C-suite as they're negotiating all the sensitive information. So the very narrow and I believe friendly amendment to this would be to just say that, and then keep all of the language that currently exists in this bill, and then add that a non-exempt employee with a salary above a certain amount can be eligible as well for a non-compete agreement. I think if you don't want to do that and you want to stay with just the language as sent, that is a workable solution with a couple problems. But if you want to make it even better, this is something to add. I'd say though that
Do you have a threshold in mind?
Well, if we wanted to stay in keeping with the region, that'd be about 200% of the federal minimum wage. If you want to keep with what 205 had for a wage threshold, that was 300%. That works out to about roughly 60,000 for the regional threshold, or 90 for what Commerce was looking at in H205. But I'd say, this conversation I've been in this much longer than I ever thought I would or wished I would be in. It's a very complicated organization, very complicated body of law. What has been put in front of you, I'd say, is a Jenga game that is at the very final stage of it, where there's really no more moves to make or the whole thing will tumble. I think this is the one narrow block you can push out of the bottom of the Jenga game and it won't fall over.
And maybe not so narrow. So I think sadly on that, we're going to have to turn to David
That'd be perfect.
because we have a lot to explore this morning. Thank you, Austin. Thank you.
Can I say something that's coloring my whole look at this? And I'm going to forward an email from 2024 from Rich Cassidy. Thank you, Rest in peace. Who was our labor attorney, who had come in quite a bit when I was chair on non-competes. It's a reminder of what landed at the federal level with non-competes. And Rich Cassidy was also part of a national group, like a streamlined commercial code of some sort of labor code, where attorneys from all over the country also found a lot of agreement around non-competes. None of it had to do with exempt versus non-exempt. I personally can't vote out a bill that is at odds with non-compete law in every other state and what the federal government came up with, which was mostly barring non-competes below a certain wage threshold. Most states have a wage threshold, and then they might look specific to certain industries. I see no reason that we kind of did all this going around and around to to exclude teachers. I would have to hear something extremely compelling on that front. I'd much rather go back to H205, which was not only workshopped, but looks a lot more like what other states have. Maybe raise the income threshold. The federal government had it at 151,000 when they passed whatever order that kind of never took effect because of the Trump administration. But I'm going to remind people that was a fairly simple, elegant, and it's where most labor attorneys in the country, as I understand it, landed, and the federal government. So I'm just personally not willing to vote something out that, because labor law has to be sort of a national coordinated thing, just like tax law.
It doesn't have to be, but it would be good if it was. So just question for our legislative counsel, Dave, sorry, hold on one second. In 205, and because we're going to hear about 205 in a minute, but was the distinction exempt and non-exempt in 205?
No, it had a salary threshold that was tied to the state minimum wage.
Thank you.
Right.
Dave. Let's good. Our time is tight. Yeah.
Thank you, Senator. For the record, my name is David Harlow. I'm a partner with the law firm Downs, Radcliffe, Martin, and I practice in the firm's labor and employment group. Thank you for having me. I'm mindful of the chairperson's comments about time, so I'll attempt to be brief.
Apologies. The Senate is just, it's a tough, we have such a limited morning time, and now it's been stretched another hour.
Understood. Well, I thank you nonetheless for having me here this
We're
morning.
delighted you've taken time. So
My hope is that I can provide some insight and some thoughts from employment and labor lawyer on the subject of S-230, specifically the non-competition agreement provision. You know Austin better than you know me. From born and raised in Clarendon, Vermont, I left the state to Rutland County.
there's your Rutland booster.
That's right. That's right.
You're good in my book.
Just ask for the moon.
I left the state to attend the University of Virginia for my undergraduate work. After that, I worked for Senator Leahy in Washington, D.C. on the Senate Judiciary Committee.
Oh, I saw Ellen McCullough Lovell last night.
Very nice. For a couple of years before ultimately going to law school at the University of Arizona. After law school, I did an appellate clerkship on the Arizona Court of Appeals, and later joined a national labor and employment firm called Opus Strategics, where I practiced for about 5 years before joining Downs, Radcliffe, Martin and returning to Vermont in 2013. During my 18 or so years of private practice in law, I've only dealt with employment law, the only thing I do. And I care very deeply about employment laws and how they function in our state, both for employers and for employees. I should add, I'm not here on behalf of Downs, Radcliffe, Martin or on behalf of any particular client. And I'm also a lawyer who represents both sides of non-competition disputes. So there are times when I advocate for their enforcement. There's also times when I advocate that a particular agreement not be enforced. It's my personal view and observation after practicing in this area for some time that we do not have these types of abuses that have led to non-compete legislation at the federal level and in other jurisdictions in the United States. I second Austin Davis' testimony about employers in Vermont adopting these agreements when reasonable. And I would also vouch for the judicial branch of Vermont. Judges in Vermont have resolved these disputes equitably and reasonably for over 100 years now without legislation. So if it were me, I would offer the opinion that there's no need for this legislation in the first place. But if the committee's determined to pass something out, I do have some suggestions to make this particular bill, S-230, a little bit better. My goal here, and I'll try to do this succinctly, is to simply point out the different legal concepts that are at play in the FLSA as compared to non-competition agreement analysis. The underlying premise of a non-competition agreement is that an employer may enter into an agreement with an employee in certain situations to allow for some restriction on that employee's ability to compete with the employer to protect legitimate interests of that employer. And those interests can take many different forms. Sometimes it's confidential information. Sometimes it's the secret sauce. Other times it's customer relationships that the employer has entrusted that employee to safeguard on its behalf. There's a variety of different factually specific factors that lend themselves to resolution on a case-by-case basis before a court. The use of the FLSA exemption standards as sort of a proxy for this highly detailed, highly factual case-by-case analysis is not ideal, to say the least. And under the current version of S230, as I understand it, it would prohibit non-exempt employees from being put under a non-compete agreement under any circumstances. And the real difficulty with that is that there are non-exempt employees who would meet the traditional century-old standard for application of a non-competition agreement when they hold those legitimate interests and thereby jeopardize their employer's business if they were to go and work for a competitor. Now, Austin pointed out an example of an executive assistant who, by virtue of his or her employment, is given access to all the same confidential information that a CEO or other C-level suite executive might have, and therefore presents the same, if not a greater risk of being poached by a direct competitor for slightly more pay, with the understanding that that person is going to know exactly what the business plans are, what the confidential information of the competitive business is. So in my view, exempting that non-exempt executive assistant actually presents more of a risk to the employer's business interests than a non-competition agreement focused strictly on the exempt employees.
Tom, just do you have a question?
Yes.
I was gonna wait till, do you have more recommendations that you're gonna make besides?
You're recommending that we go to salary.
Well, what I would recommend in this particular instance, if you were to use this as a framework, would be to add something to it that allows for the employer to pay non-exempt employees over a certain threshold, let's say 60,000, and that effectively would give the employer a tool to safeguard itself. If you have to raise the income of a non-exempt employee in order to be able to enforce a non-competition agreement, that might be a reasonable solution for an employer. As it currently stands, there's nothing the employer can do. You can't, as an employer, make a non-exempt employee exempt. Their status under the FLSA is determined by their job duties, not by how much money they make. So that's the fundamental problem. I would also just point out that the executive assistant in that example is not prohibited under a non-competition agreement from working as an executive assistant. Not at all. That executive assistant would be prohibited from working as an executive assistant for a direct competitor of the employer. So if you're in a small niche industry, which many Vermont businesses are, you'd be prohibited from working for one or two direct competitors, not as an executive assistant in any other industry. So that problem is real. There's another example that I think I'll point out very
Yeah,
quickly.
because we really need,
Very
a
quick.
lot of people want to chat about this.
Salespeople. Salespeople enjoy customer relationships that have, throughout the history of Vermont's jurisprudence on this issue, been a basis to enforce a non-competition agreement. Salespeople under the FLSA are often non-exempt. There's an outside salesperson exemption, but there's not typically an exemption for an inside salesperson. In 2026, there's very few door-to-door salesmen going physically door-to-door. Salespeople currently usually don't meet that outside sales exemption that's drafted in the 40s. So my recommendation would be to include some form of income threshold that the employer actually has the power to implement that non-competition.
Great, Tom.
Dave made a question, but you don't have any other key recommendations you're offering. Those are the recommendations about the income threshold, just to be clear.
If you were to adopt S-230, that would be my recommendations.
Great. So I agree. And one concern with this approach is that it's just using non-exempt. It's just not the right approach because it really should be about income. If you make less than a certain amount. But the other half of this that I'm concerned about is that this won't address so this addresses the high paying non-exempt. I'm worried about the low paid exempt employees. And since you have employment law and you mentioned this isn't an issue in Vermont, with a quick Google search, I'm worried about, I'm going to use names because this is what came up in Google search, like the Dick's Sporting Goods or the Dollar General, the large chains applying these non-competes for assistant managers that are making $45,000 a year or so, asked to work 60+ hours a week. You put a non-compete on them so that they have to stay within that chain and move elsewhere, uproot their family, go elsewhere, rather than maybe looking across town to a competitor. That gives me concern. So I don't like this non-exempt exempt, but I'm curious if you'd reflect on that approach, that aren't there exempt employees making less than a certain income threshold that really should be bound by restrictions that aren't really fair in the labor market?
Yes, there are exempt employees who, under certain circumstances, should be bound. But the generality of that example demonstrates, I think, why these disputes are best resolved in a case-by-case basis by judges. Because there are going to be certain non-competition agreements for certain exempt employees, certain managers, which I think we're all going to agree are reasonable, warranted for the protection of the small business. The assistant manager for Dick's, or for, I can't remember. Dollar General, something like that is unlikely. It's unlikely to pass the test that currently exists.
Right, exactly.
If Dick's were, if Dollar General were to attempt to enforce that agreement, what I would tell them is you're going to waste about $75,000 to $100,000 attempting to enforce an agreement that you're going to lose on. And as a result, that doesn't happen.
So I'm gonna have to move us along because we have a bunch more to hear from David.
Just
You
very
remember
quick
about-
question. So
Yeah.
going back to the very beginning, you
Yeah.
support the addition of this section 3B with his agreements, not the non-compete agreements, the prohibition of non-compete agreements. Is it necessary?
I think any change to legislatively that would limit non-competes, in my view, is unnecessary. But I'm sort of saying, I
If we're
understand it's
gonna do it,
politics. If you're going to do it, we need
Do
to
it
do
with
it
a
right.
salary threshold and not exempt, non-exempt. That's what I'm hearing. Right,
If you're going to use the exempt, non-exempt dichotomy, you would also need some third outlet in the form of salary threshold, right?
thank you.
Just because of his expertise, I'd like to throw one more question.
Yeah.
Okay, so
And then David's up.
to your previous point, though, I'd also say that those non-competes, even if they're unenforceable, they can have a chilling effect on the laborer that doesn't know what their real options are. And when they're told that they can't go somewhere else, they won't. And so then they'll have to work with their family. But you raised another point that is a piece of this discussion. You said legitimate interests. Like, would you tell me what you personally think are the legitimate interests that a school district has to prevent teachers from applying to other schools on their terms when their life circumstances suggest they might want to work elsewhere?
I'm gonna have to say I don't know, because I don't practice in the field of public education.
Okay. So you don't have a strong opinion on that?
I would say I don't know.
There are other people in the room who I think probably have a strong opinion about that.
Thank you very much.
Having looked at who's in the room,
Question for you. Where is the teacher legislation in here?
it's in 205. It's not here. That is why, that was the issue on the floor that Troy Hedrick raised. That was the issue that pulled it off the floor back in onto the wall. And that is what House General did, was they took the non-compete piece that was a little narrower out and put it in this. Thank you, David, so much. Lovely to meet you. Beth Radigan, do you work, which office do you work in?
Well,
Obviously not in Lebanon.
I'm not in London. I live in Middlebury. My office is Rollins.
Yes, well, Beth, we've got labor lawyers all over for the area,
That's
which
true.
is great.
That's true.
Thank you very much for taking the time today to come down.
Sure.
David, come join us.
David McBurk here on behalf of
working Vermont, I once echo many of the things that Austin said about the work that was done around H205, not the bill that you're seeing in front of you, but the bill that was voted out and nothing out of the Commerce Committee. I think there was a lot of good work on that. The one unfortunate thing, point that Senator Chittenden just brought up, is that while the bill's intent, and I think you should read the intent if you get a chance, it's very broad and really says that we should be discouraging non-competes generally across the board. That intent wasn't in line with one aspect of the bill, which was to sort of systematically exclude one particular we were opposed to. So I just also want to frame this a little bit. This is from a press release from the current FTC that said, once again, this is from a month ago. Once again, the FTC is fighting for American workers to ensure that they have the freedom to pursue new job opportunities and better pay, said Daniel Ganera, director of the FTC Bureau of Competition. The American economy runs best when workers are not limited by non-compete agreements that distort competition and prevent workers from changing jobs, starting competing businesses, and earning higher wages. The FTC's actions today build on its work to enforce the antitrust laws to protect American workers. And that was an action that they took against pest control companies that affected about 18,000 workers across the country, perhaps in the state. I also want to just correct one thing for the record. House Commerce did hear testimony from Vermonters that have been subject to non-competes. There was a chiropractor that gave very compelling testimony about her experience and how difficult it was on her life and her economic future. So that's just.
We have I understand and fully appreciate how much time House of Commerce took on this.
Yeah.
It came out 10-0.
Yeah.
It was a strong bill. It was the Achilles heel in it seems to have been the teacher piece, which I assume also took a huge amount of testimony on that aspect of it, or not.
They did take some testimony. Yep.
Yeah.
So, I mean, a simple
But,
solution.
and that didn't have exempt.
No, 205 had no exempt, non-exempt.
So one option for you, one recommendation would be to take 205, add the Hedrick Amendment and move forward with that.
I love that.
And the Hedrick Amendment, is it Hedrick or Hedrick? Hedrick. Anyway, the Hedrick Amendment did what? It just forgive us for those of us who.
Sure. It clarified that teachers, which have been subject to a version of a non-compete provision since
Be
1865.
exempt
Yeah,
from that.
they would also be included in the bill
Right,
and
the
not be
teachers
subject to non.
Would all be exempt.
Exactly.
And teachers and staff, because a lot of this, right, everybody would be, but not,
Based on
Yes.
the income threshold.
Yeah.
Which makes a lot of sense.
Jeff, is that,
That is correct.
One thing I'll
Bannon for the record.
yeah.
One thing I'll mention also, this idea that we can just leave it up to the courts. Well, for a lot of workers, we don't have the capacity to go to court to enforce.
I was gonna say exactly the same thing,
Yeah.
which is who has, particularly for very low pay, who has the money to go to court? They don't, and that is the prohibiting and chilling factor. So your recommendation at this point
At this
is,
point, would be to take 205, include the Hedrick Amendment, and then send this back for consideration. House.
thank you, Thomas.
So I definitely support that approach for a couple of reasons. One, H205 was well vetted. There was a lot of concurrent. It was going to 10-0. There was just support for it. It was a good policy. And the Hedrick Amendment addresses what I see as a real issue in current Vermont labor law.
Good question,
teachers-
reflected that.
Teachers are, as I've heard the governor say, okay, it's not that we're paying them too much. You look at how much teachers get paid in Vermont, they are not paid more than other states. The argument, though, is that we have too many staff in our schools, like paraeducators and so on. So that's the debate. But the teachers themselves are not getting higher pay. Right now, what my experience, I'm married to one, I love her. All right, this is a very problematic rule that she had a very small window where she can apply to other jobs and she effectively can't. So this non-compete where teachers making 45, 50,000 a year, they effectively can't go, they can't upward move, taking their skills and go to other school districts where it's needed without additional without completely, either quitting their job or otherwise. So we didn't take testimony on this, but I know the House did, and I definitely support us addressing this problem, which has percolated for years. We want to hear the VSBA, and we can qualify that there isn't enough time, but just because there isn't enough time doesn't mean I'm going to support S230's approach, which I think is flawed for multiple reasons. And I think the H205 approach makes a lot of sense and it's fair.
Right. So this will all take a little more time because many people, we haven't gone through 205. So that's one of the options that we have in front of us. I appreciate
One
this.
last thing.
Yes.
I would not,
And then,
I would not support, if you're sticking with the 230 framework of non-exempt, I would not support an income threshold. I think that's just limiting. I think that just means fewer people are going to be protected, and more people will now have a restraint on their ability to seek employment that works for them.
I don't disagree. The question is, there wasn't income threshold. Wasn't there an income threshold in 205?
There was,
There was.
except for it was much broader in terms of who
it applied,
who it
okay.
applied to, and there was a test, not just an income threshold, but a 3-part test. Which made it very clear when these would be appropriate or not.
Right. Cation.
So for the sake of not confusing people, I'd say let's just set aside the exempt, non-exempt thing for a second. I don't think it's good policy. Let's just talk about the wage threshold. What do other states' wage thresholds look like? Because I mean, whatever testimony we receive, I believe if you're going to ask somebody to work hard for you, extra hours, build customer relationships, build a lot of value for your business, we should increase the wage threshold at which you're essentially paying them to be entrapped a bit for working for you. I mean, the personal assistant example, I think, is a great one, right? Like Elon Musk had a personal assistant who was loyal to him for decades, who he, summarily fired one day when she asked for a raise. So we should make sure that the income threshold, I think, is more in line with the federal one that was proposed, because otherwise these are a tool that an employer could just put on somebody at what's actually a very low wage in Vermont. That's 90,000 is area median income, not,
not for my area, but maybe. So what
I don't know, it's my region.
So I would suggest
90,000 is area median income for our area. I just like to use a higher threshold.
I heard 151 from you. Yes. So I thank you for this, because we have some decision points and we have a lot more time that this will take, which is fine. I'm not being critical. I'm just saying there are a lot of other things that are being, there's one other major piece that's being proposed, and on the non-competes, we have Jessa and Chris still to hear from.
10 seconds.
And then we have the
And then
SEA.
that's it.
Yeah.
Okay, just one quick related to the executive assistant example. Nothing in this bill prevents people from being covered by an NDA, a non-disclosure agreement. Nothing in this bill allows people to reveal trade secrets. And what we're saying in talking about that example is that we want the burden to be on employees that are subject to non-competes to go to court, but we don't want any burden to be on employers to enforce the law around NDAs and trade secrets. So I think it's, I just think there are other ways to get at those issues, and nothing in 205 or 230 would affect those particular ways to protect that information. Thank you.
Thank you very much, Dave.
Question for you, Madam Chair.
Yeah.
Can we get a copy of 205 and the Hedrick amendment?
We look at it. I think that's great. We can just go right out the bin. Maybe Kiara could go out and get it.
Well,
We will, if we,
awesome.
Go
And the
ahead.
Hedrick amendment.
Yeah, awesome.
so we have, at the moment, so you're gonna have Jessa and Chris come and chat first. And, I can't remember who's on deck next, but I think it's Chris. Chris, come and join us for a sec, and then Jessa, and then we're gonna have a brief conversation about what we want to do about that piece, and then we have another proposal for this bill from the VSEA. So, and I'm going to do that all by 9:30.
For the record, Chris Delia, President, Vermont Bankers Association, was the one at the request of Chair Marcotte that pulled everybody together over the summer to have this extensive discussion.
You were part of 205 also.
I was part of 205, and as you are discovering very quickly, it becomes a very complex issue that has a lot of moving parts to it. So I am going to just offer our support to work with the committee as you go forward over the next few days on this. I will say that in support of Jess's community, there wasn't any opposition to finding solutions for the groups that she represents, both in 205 and in work that was done in House General. But you are embarking on a very difficult discussion that as soon as you solve one issue, there will be other questions that come up around it. So it's not an easy path forward for you in a short period of time.
Why, thank you, Chris. That,
I think it is, but I want you to know
Sometimes
the
we
reality you're getting into right now. This
right,
is-
sometimes we do very good work under pressure. Keisha.
I guess I would just ask, if you've heard any complaints from the bankers you work with in other states that generally just have a wage threshold on compete.
I have not heard complaints from other bankers regarding wage thresholds. It's not just a wage threshold, it's also the work that the individual is
So
doing.
industry by industry sector.
So industry by industry. I think there was general consensus and agreement that for the examples that you highlighted, Senator Chittenden, there's no reason why there should be non-compete agreements for individuals in those types of job positions. It's when you get into higher level positions and the type of work that they're doing for the entity, with the information that they have access to, that's where you're starting to get into the serious discussions.
Right.
However, you're also going to find the opportunity to get into discussions about other agreements that surround non-competes, deferred compensation, forfeiture for income agreements, because they may have non-compete language in them. Because when I retire, I defer compensation when I retire. I cannot go to work for somebody else, otherwise I will lose that compensation. It just starts to snowball and snowball. So what's in, what's out, what needs to be clarified?
But that was covered and addressed, I believe in that.
95 for no. We made some
We could also leave some of that for another session. It's just why we keep running, is to keep dealing with these issues year after year.
I'd rather not, but
And
yeah,
lobbyists deployed.
I don't
Sorry.
think so.
So,
and
were you in support of this work of
We-
205?
We supported 205, extensive work that was done on it. I had one issue come up after 205 came out of the committee, which if it ultimately gotten to this side of the table, I would have brought to your attention, which is on the clarity for compensation agreements. But beyond that, we support it. But
Okay.
Communicated that.
I will.
Great.
I didn't think we were going to get this far.
Listen, we move fast in this.
I know.
Thank you very
Thank
much. I'm gonna ask Jess to come up and then we're gonna leave some time for BSEA. But first, we're going to look at,
Thank you very much. Jessa Barnard with the Vermont Medical Society. I will try to also be brief, and thank you, Chris, for teeing up some of the background. There are sections in 230, also 205, that are specific to healthcare, and this is not unique to Vermont. A number of other states have addressed non-competes and other employment practices in healthcare specifically, sort of categorically for those professions.
Same, it's like Maryland or.
They are in, referenced in my testimony,
which we have.
which you
Just
have
wanna remind
posted,
everybody.
and middle of page 2,
Just tell me your
Yep.
favorite one.
my favorite one. I would actually say, Massachusetts, New Hampshire, Wyoming, all have pretty similar language to what we're proposing, or what is actually currently in the bill.
Mhm.
But then a number of states have laws specific to healthcare providers. The difference tends to be which providers they include. And we recommend being broad and using Vermont's existing underlying statutory definition of healthcare provider, which is pretty broad. We don't think it makes sense to carve out certain types of healthcare providers from others. And the reason, healthcare is different in that if you are restricted as a patient from seeing or following your healthcare provider, that really restricts access. We're a rural state. We already have access issues. We know we have workforce shortages. We don't want any other barrier to patients being able to continue to see their healthcare provider in a rural community. And this is echoed. The American Medical Association supports banning or not having non-competes in healthcare. The Federal Trade Commission has issued letters recently to staffing and employment companies critiquing their use of non-competes. We actually know they are used in healthcare, not extensively in Vermont. The real issue we actually see in Vermont is out of state staffing companies using non-competes, especially in the area of nursing or temporary position placements. And that local Vermont employer may want to keep that person on after that contract ends. And sometimes those contracts prohibit that. So you may have a temporary nurse in a long-term care facility. That facility would like to keep that nurse local, pay local wages, not pay the staffing company a huge premium above those wages. And then there will often be provisions in those contracts prohibiting that nurse from accepting.
And I believe that kicked in also with traveling nurses.
Exactly. That's what exactly. Traveling nurses, traveling physicians. That's actually in Vermont where our understanding is the most of them are present.
Yes. Okay.
So I'm not sure I am with you on a blanket non-compete for healthcare workers. I have to look at that definition. I'm looking at Massachusetts, the details of Massachusetts law, and I'm reading one legal document from an attorney's website, so it may be incorrect, but if you can tell me your understanding, they have industry or profession regulation on lawyers, physicians, psychologists, nurses, social workers, broadcasters. If we did something related to physicians, psychologists, nurses, not sure about social workers, but I have to look into that more. But physicians, psychologists, and nurses for your all purposes, what is captured in all healthcare workers that we think?
Well, I'm wearing multiple hats here. Let me just disclose. So I represent physicians and physician assistants.
Mhm.
I will also say I am informally, there is a whole coalition of healthcare associations that have been working on this issue. And it all started in a third bill, 583, which is about private equity in healthcare that started in-house healthcare. That had provisions on non-competes, non-disparagement that were then taken out because it was moving in 205. Then 205 had its issues of not moving. So then it is in 230.
Moved and then
ground to a halt. Then these were sort of imported into 230. I will say sort of everyone weighing in on all of those various steps has been looking at a broad applying to all healthcare providers. So, for my organization, we would want to see physicians and physician assistants. I will say, sort of speaking on behalf of all of the entities following this issue, as it's landed in various places, we've all been in support of a broad definition of all.
There is a definition that exists that we could go with.
There's an underlying definition in state statute, and Sophie, I know, has it.
Then we can look at that.
You can look at that. And I will say it is broad. It doesn't list necessarily profession by profession.
That's your preference.
Our preference is to just keep the existing kind of broad definition.
Can you speak to physician assistants though?
Mm-hmm.
Only because, again, I could see that's like a subordinated position, to somebody, and they may really want to leave. It's like, so as we talk about like the independence of physicians and having some level of competition that might be healthy for.
So we actually had interesting feedback even from independent practices.
Mm-hmm.
So
I'm
actually going to pull this together because I think if we have some choices and the committee has to help me make this decision. I'd like to have you finish and then I'm going to have a brief conversation. And then we're going to turn to the VSEA request. So I just love to have you finish, and then I think we just need a brief conversation about the direction we want to go.
I will be very high level. We are most in favor of the current language actually in 230. It is very similar to what was in 205. All the concepts are the same, but there was just some refinement of language that we actually think is a little more specific. So we actually support I would call them minor revisions that were made between 205 and 230.
Just on the healthcare.
Just on the health. The
So
only piece we were weighing in section 3B, I believe it is, specific to healthcare providers. That is the only section of the bill we have a position on. We have not heard any opposition in all of the stops this language has made throughout the building in terms of the direction of that language.
Right. Thank you.
Yes.
So I'm going to take a pause before we hear from VSEA. Thank you. I appreciate everybody. This is terrific and very helpful. I believe, as I looked, having just come out of a chairs meeting yesterday, where we are being given Friday as our deadline, we have the opportunity to have a few hour and a half here, hour and a half there next week. I'm sensing, and I haven't heard from Randy and David, but I'm sensing that people, we have some options at the moment. We can accept 2:30 as it came to us right now. We can accept 2:30 with looking at 2:05, which will take us a little more time, but looking at 2:05 with the Hedrick amendment. And we also have the option of doing 2:30 with 2:05 and maybe adding this VSEA request. So those are the sort of the options. And I just need to hear, because if we are happy to take the time to look at 2:05, that we're not going to do that today. We'll do that probably Monday. Remember, we saved Monday 9:30 to 11:30 or 9 to 11:30, something like that. We had talked about that. We could chat further about that. But we can make time to look at 2:05. It's going to have to be very tight, and we're going to have to make time for it. So if people feel that they would like to do that, I'm happy to do that. Also, I would like to, we need 10 minutes to hear the request from PSEA, because they also, what we just discussed really relates to the bill as passed from the House. And so those are the options I think that we have within the bill that has been sent to us. The SEA has a proposal that's an addition that has not been passed by any committee in the House. And it would be a new piece. So I think we also have to hear from that and see if we want to add that. But at the moment, what are your thoughts about 2:05 and the Hedrick amendment? Do we want to hear more before we make a decision on 2:30? David and Randy, I'm pretty clear on this side of the table. On yes to 2:05 with the Hedrick amendment. So Randy and David.
We want to hear that.
What I'm hearing is the language currently in 2:30 is not viewed with much affection. And there's interest in looking at 2:05 with the Hedrick amendment. That will take us some time to understand and appreciate, which I'm happy to give.
But the question that I have is, have we heard from every group or segment that ought to be represented in this?
We're not going to have time to do that.
Well,
we're
if
going to
we
have
don't
time
to do it. We shouldn't do it.
Right. We're not going to have time in the time we have available. They took, the whole beginning of the session. There was a lot of time spent on 2:05.
Is that perspective represented in any discussion that we've heard in here? Is my question.
Well, we can all take some time to look at some of the tape that from, if we want to do this, we're going to take some time to hear what 2:05, the final work of 2:05 that was passed out of committee, which you have in front of you. You have the Hedrick amendment. We're going to have to do a little work on our own to be brought up to speed.
If we have looked at this thoroughly, my question is, have we heard from or understood the positions of those people other than those who were in the room as groups?
We will by the time we look at it. The question is, do we take the time to look at 2:05 plus the Hedrick amendment? I'm getting a strong support from one side of the table before we pass 2:03. Another option is to pass 2:03 with 2:30 rather, with none of these additions.
No.
And
I really want to hear from Senator Weeks, but if I could just frame one more thing. So to your point, H205 is well vetted. It came from a study committee. It got unanimous support. It was a good
excellent.
bill.
That's what we just heard.
So where I currently am, what I don't like in S230 is this is a haphazard approach that no other state's doing at cutting along consent. So what I'm sensing might be an easy path for us is we take 2:05, put Hedrick amendment aside. Okay. H205, that seems like it's very clear, and replace the S230 with that. And then we can have the debate about the Hedrick amendment, and that might be where we can focus if we can squeeze any testimony.
Right.
Is that an option, Madam Chair?
That is what I'm describing, is we can take time to appreciate 2:05 and include that in 2:30. Or of course, we have the option of doing 2:30 without the non-compete at all and just do 2:30 as we voted it out of this committee. David, what are your
Well,
thoughts?
certainly happy to hear about 205 and recommend it and such. I do understand we're running out of runway. Next week is going to be a problem. Monday is probably going to be absorbed with education, absorbing all the oxygen in the room.
Are you doing afternoon meeting and education or morning? Because Seth and I can coordinate that.
Monday, as we did this last week, like I said, and afternoon. As far as I've been aware of this, there's a lot of issues without traction in that committee that are going to absorb our effort.
Okay.
But I'm happy to hear about 205. I don't know anything about it until this morning.
Okay, great. So I think I have a sense of the committee. We're willing to do 230, not as without the non-compete as it is at the moment, looking at the non-competes in 205 and the Hedrick Amendment. Okay, we will make time to do that. And now we're going to turn to the VSEA. I'm sorry, we're running out of time here, but give it 10 minutes. Al Gordon, welcome. If you would frame up the request.
Madam Chair,
Yeah.
I want to go back to what I said before. I'm not going to be satisfied with anything until I have the answer to the question. Have we not talked to anybody, any group, or any effective population that has not been discussed in what's discussed thus far? What are we missing is my question.
I don't know what we're not missing
Well,
at this moment.
that's what I will be seeking to find out.
I'm
Sure, how many people in this room, for example, are subject to non-compete agreements?
Well, I guess all legislators are because we have to.
No, I'm not
can't
talking,
work.
I'm not
We have
talking
none.
about legislators. I'm talking about in real jobs.
My wife is.
Yeah, his wife.
I
is.
am.
You are, David is, and yeah. So we will discuss that further. Thank you for weighing in. And Randy, we're not going to do anything until everybody's satisfied and on board. So with that, Al Gordon, take it away.
Good morning and thank you. And my apologies for not being able to be with you in person. For those who have never met me, my name is Al Gordon O'Connell. I'm a labor lawyer, and I've been doing that for about 30 years, first as a labor investigator and prosecutor for the federal government, and for the last 22 years in private practice, representing unions across all industries, all sectors, public sector, private sector, state, federal. I currently am the managing partner of Pyle Rome Ehrenberg, which is the largest union law firm in Vermont. And I serve as general counsel of the Vermont State Employees Association, who've asked me to sit with you for a few moments today. The request from the VSEA with regard to the legislative change really is seeking to close a loophole with regard to solicitation on state premises, and particularly on premises controlled by the Department of Corrections. State Facilities Rule 1, which is passed by Buildings and Grounds, completely exempts Department of Corrections, but for all other state facilities or most other state facilities, already exempts nearly all solicitation on state grounds. And that includes labor union solicitation. There's one minor exception I'll get to in a moment, but that's the existing state rule. DOC is exempted from the state rule, and although there's no legislative history of an administrative rule, it seems clear that the reason that the DOC is exempted is because the Department of Corrections commissioner should be permitted to create more restrictive rules around secure facilities, particularly facilities that house incarcerated individuals. But the DOC commissioner has never passed any such rule with regard to the outside of the facilities, the grounds of the facilities. And so what VSEA is seeking your assistance in doing is closing that loophole to prevent wide-scale solicitation on areas controlled by DOC outside of the facility, such as the parking lots, where our members every day must come through and to in order to get to work. I did mention that there is an exemption for labor organizations in Buildings and Grounds Facilities Rule 1.
Buildings and General Services, Al.
Yeah, I'm sorry. Thank you very much.
That's okay. I know it's
right. Moving fast today, just trying to get through your schedule. But the State Facilities Rule 1 already has an exception for labor organizations, but only in one limited capacity. There is a provision in SELRA, Section 909 of SELRA, that allows access to the exclusive representative to have access to new employees right after they're hired, to give them information about their union to determine whether they wish to join that union. That is the only exception. The only other reasons that the exclusive representative, currently VSEA, would have access to the facility would be to perform its statutory functions, such as coming on site to represent an employee in a Loudermill proceeding or any other kind of investigation. And so all that the VSEA is seeking here is to extend the no solicitation rule to the grounds of DOC facilities to have that same protection. And it treats everyone the same from a solicitation point of view. No one is allowed to solicit on those premises with the single exception of CELRA Section 909 for new employees to have access from their exclusive representative. So ultimately, this closes a loophole, has the DOC facility comport with state facilities Rule 1, and also U.S. Supreme Court precedent around an employer's ability to control its premises. So it's a very simple approach. We're hoping that the committee will endorse it.
It may be a simple approach, but every time somebody says something simple, there are ramifications, as you know. Unfortunately, this is a new proposal coming to us at the end of session with, as you've heard, we're fighting for every hour that we spend together after Friday. So this is coming to us. This you've proposed this, I believe, in Senate institutions. They chose to not take it up. Is that correct?
I believe that's correct, but Tom Aldenor, who's across from me.
Was it proposed in House institutions? Because they feel.
Well, could we ask what happened in Senate? I feel like we're
okay.
What happened? I have no understanding of what is happening right now.
Okay. So Tom and Al, you'd be kind enough to share with us what happened. And because the Committee of Jurisdiction on State Property would probably be, and is all in all likelihood, is our Senate and House institutions committees. So what happened in the Senate Institutions Committee? Could hear from Tom or Al.
Madam Chair, for the record, Tom Applemore, VSEA's coordinator for external government affairs. The committee briefly reviewed the proposal, and I believe I don't want to speak for either Chair Harrison or the rest of the committee. I believe it was essentially the same scenario whereby they had a short period of time in order to review this. And there were, as I think the perception on the part of the committee that it might be better handled by one of their counterpart committees in the Senate. So they ultimately decided not to take action on this here. Not, I don't believe, due to any opposition to the proposal, but simply because of the perspective.
Timing. Well, the timing is an issue for us as well.
Well, I don't. Okay, so let's.
So, and let me just finish on House. So was this proposed in the House?
There were brief discussions in the House, but it didn't arise to the level of testimony in the committee.
Okay, so this hadn't been passed by the House.
Correct.
And the Senate Institutions Committee chose not to take further and send it to us.
So here's the problem with what happens, particularly to state employees or any labor issue that comes to our body. There are 3 committees of jurisdiction: institutions, GovOps, and in some cases, economic development and labor. I think the concern that I heard from the committee institutions was that the concern raised about the problem with this was a labor standard.
That's correct, Senator. And so I believe it was the committee's decision, not necessarily that they didn't have time as such, but that it might be dealt with by the committee of jurisdiction for labor issues.
Right. The question of is for some reason excluding corrections workers from not experiencing vending, whatever, in their parking lot, a prison issue, state employee a state employee government issue, or a labor issue. And they were told that it was a labor.
I think that's right, Senator. I think that was the guidance.
We are the only ones who can answer that question. So I just want to be fair that it wasn't that the other committee said we don't have time. They're not the committees of jurisdiction for this issue. We are.
I think that's right. And I think, Madam Chair, the desire on our part to have Al be able to join us today, and as you're having these discussions, is to clarify that making this switch with regard to the proposal would be well in line with all of existing state labor law, with the precedent that exists with regard to all other state buildings.
We will hear from our legislative council.
If I could just say,
I have other people that we have lined up to weigh in
On this issue.
on this issue. We have Wanda
Okay, so we're
Manoli,
not
and we're
ignoring.
5 minutes over time. So Wanda, who is with us, Beth Buster, and Wanda, neither, they both rang off.
Yes.
Okay, so, Keisha.
Oh, great, thank you. So I haven't really talked to anybody about this. It's just sort of, you know, when we think about this issue, like, I just don't know if other people have an image of in their mind of what it feels like to be in a parking lot in corrections. I used to spend time in the women's prison in Chittenden County because of my work as a legal advocate for victims of domestic violence. And when you enter or exit a place where you have to remove everything from your pockets, you cannot have
I've done the same.
literally anything with you. You are in a space that feels enclosed and confined, and time, you know, and space start to escape you. That parking lot actually became a very important place for me to like collect myself, because it's a very intense thing to enter or exit a corrections facility. I have no idea why they were originally taken out, but like, this seems very simple to me, and I don't know who opposes this.
I believe our legislative council has thoughts on this, and I would like to hear from Wanda about the history
But
of
that
it.
wouldn't be opposition. That
I
would be an
believe,
opinion.
no, there'd be history, which is not an opinion, it's a fact of why corrections was carved out. That's one question. And second, again, we have very little time. This could be dealt with next year. This is not a pressing issue that has to be solved this moment. So, I would like to take 5 minutes just quickly to hear from our legislative council as to this proposal that we have in front of us. So, do you want to just speak from there? Yeah, okay.
It's Sophie Sadati for the Office of Legislative Counsel. Yeah, I mean, I don't have any additional information really as to why the Department of Corrections
Right,
was
that's what we were hoping
separated
Wanda
out.
and Beth was.
So there's a facilities rule that's issued by the Agency of Administration, BGS, that was passed in 1999, effective 2000. So that's the current facilities rule that Al was talking about that has this carve out for the DOC. I did look in statute, so the Commissioner for Buildings and General Services is the one that is directed to develop the rules around facilities. There are some carve outs for some state agencies, but the Department of Corrections is not listed as one of those. Under the Title 28 dealing with the Department of Corrections, the Commissioner has authority to oversee the operations of the prisons, and the department has been delegated authority to develop the rules around the Department of Corrections. Again, I couldn't find anything online with regard to rules governing the exterior of prisons. Obviously, there are rules around who can go into the prisons. So in looking at this in the proposed language, if this were to move forward, my thought would be to put it into Title 28 under the section that deals with the administration of prisons. So it would be in there, I guess
And not in the Fair Labor Practices statute.
well, because the way it's drafted is specifically around the facility,
Right.
right? So I think that is what would make sense. I think that's where people would look in terms of rules around the facilities for the Department of Corrections. So I guess I would be keen to hear again testimony from the Department of Corrections or Buildings and General Services in terms of the current policies and why there seems to be why the DOC is carved out, whether there are any rules that I'm not aware of out there governing parking lots.
Yeah.
Have you heard why DOC is carved out from 1999 onward?
I believe Al's testimony earlier, Senator, speaks to that. It's Al, I'll ask you, I guess, to reiterate your point.
Right. So the statute does give the Commissioner of Buildings and General Services the authority to control the outside of the DOC facility. She has delegated her authority on DOC facilities to the commissioner of DOC, which is presumably because of the expert of the commissioner of the DOC in controlling secured facilities and the surroundings. There's no other language anywhere that we're aware of.
Okay, so it was, I got that part. So there was no, at the time, it was just, they were missed. It wasn't like somebody wants tacos in the parking lot or something.
Well, I think, in all fairness, we should hear from Wanda, and because we've asked Wanda for the history on this.
Do you know what Wanda's been
I
doing?
don't.
Okay,
I asked her to come and testify. So my
It's hard
question,
to get me, just.
okay, we have some other things to do. I think one of the questions I have to the committee now is, as we look at S-230 as a vehicle for this, we've made the decision to get more on 205 and on the non-competes, and we'll be looking at 205. The question is, do we also want to take up this and look at the history of this and make a decision about including this in S-230? And we will, and we can make a very short amount of time to look at this as well. So, how are we on this?
I'm not against this language.
Willing to hear more?
Certainly willing to hear more.
Okay,
Not
I would-
opposed to it, but don't know enough.
okay. So, we will aim to fit in both the VSEA discussion and the non-compete discussion next week, with some specific time, but it's gonna be, it's gonna be short. So we're gonna have Wanda, we'll have Beth, and Al, if you could be on deck when we're back, and Sophie, we'll be to deal with this next week. And your proposal is then to draft this. And you have said, I believe you've said, so I know Sophie has the language, but we could do it in Title 28.
It would be just a new set, my thought would be a new section, it would be section 129 from Title 28.
Great. Okay. We will look at that next week. Thank you, everybody. On S-230, we're now going to shift to S-173. Because we have a question about whether to concur or not to concur with the House proposal of amendment on S-173. And David and I spoke, and Sophie, if you could stay with us on this. David did his work talking to Jay Ramsey, I hope, and I did
Jay's on holiday. We do have some feedback from
Marcotte.
No, we do have some feedback from labor.
Yeah. Great. Terrific. What are your thoughts?
I think that the apprenticeship section is, don't want to necessarily speak on behalf of.
Do you want Rowan to?
I think it'll be more appropriate,
Okay.
rather than being the monkey in the middle. It's been advised not to be the monkey in the middle.
You are not the monkey in the middle. You are the reporter of the bill. And Rowan, would you join us at the table, please? Thank you, because this was a request of Department of Labor, so it's great. And Marcotte, I spoke to Mike Marcotte, and they're.
Thank you very much. I appreciate you having me. We don't have for much time, so I'll make this quick, but I'm Karen Hawthorne, the Policy and Legislative Affairs Director at the Department of Labor. The changes that are in S-173 were requested by the Department of Labor. Act 55 of 2023 changed the entire registered apprenticeship statute. We made a lot of updates for federal government guidelines, really kind of changing it to what we wanted to be, we want the program to be. And so within that, we have there was report requested that we work with the Office of Racial Equity to look through all of the updated language to see if there's areas of improvement to make sure that apprentices had access. It was equitable, any changes we should make to make sure that everyone who wanted to be part of the program could be. And so that's what the language reflects in S-173. We're in full support of it. There is nothing substantive in any of the changes, and I'm happy to go through.
That's okay. I think we went through them. We went through them yesterday.
Fantastic.
And David.
Yeah, I just wanted to make one comment. This is an observation. Maybe I made yesterday, but the apprenticeship section applies to, there's a list. One of them, B on page 7, is anyone living in a rural area. The federal standards, all of Vermont is a rural area. So it just kind of negates
everybody.
Yeah, as far as there's no real distinction between who it applies to. It seems interesting.
That
It's recognized.
it is recognized and it's really to make sure that there's eligibility as across the state. And so in that particular section, we took out some of that specific language identifying groups, because it's not really about the groups of protections associated with this section or in other parts of labor law. And the focus of this was to be identifying barriers that we see here with the protections still existing for those groups in other areas of labor law. And so it does realistically cover the whole state, yes.
Reporter, I think, given that, I would entertain a motion to concur with the House proposal of amendment.
So move.
And we'll do a straw poll on it because we don't have possession of it, but we can. We don't have possession on the floor. We don't.
Oh, okay.
So yeah, it's working. So we could ask to have it. I mean, if there was a lot of work, like on S 230, we're gonna ask once we get it, we're gonna ask to take it into committee, I think. So,
If we do, then it adds like another warning day. So are we just gonna pass over or are you gonna take it into committee?
we'll see when it arrives. The topic comes to me. So we could take Senator Gordon.
So we're actually voting,
Yeah, let's draw up pointer.
Senator Brock,
Yes.
Senator Chittenden.
Yeah.
Senator Robinson,
Yes,
Senator Weeks, yes, Senator Clarkson.
Yeah.
Chittenden.
thank you.
So I assume I'll tee up as a.
Yeah.
Very good. And
Right, and I think that Rowan can get you some language on what this accomplishes and what this does. And we'll go from there. Right,
Thank you very much.
thank you very much. Thank you, Rowan, for coming over, and I hope Jay's having a ball wherever he is.
and I reference it as a House proposal. amendment.
Yes, absolutely.
That's 2:30 is up today,
On the floor,
Yeah.
on our calendar,
right at the very end, but yeah.
of the House calendar.
Of
Our
the Senate vote.
Yes, so I am going to, so just to finish on S 230, I am going to ask to bring it back into committee and where we'll be able to work on it. So, thank you. So we're going to launch into H 211. People need 4 minutes and, because we have people waiting from California who've gotten up early to join us. We will rejoin at 10:10. Okay? So if we go short, that would be great.